The distinguished gentleman from South Carolina is recognized for 5 minutes.
Thank you, Mr. Chairman. Thank you for having this hearing today. Thank you to our witnesses for your time. Under federal and state law, asset managers owe fiduciary duties to their clients. What does that mean? Well, it essentially means that they put their clients' interests first. This is a concept that is old as time. It's become increasingly clear, however, that asset managers may have violated that fiduciary duty, based on your findings, to their clients through signing radical ESG pledges. Attorney General Reyes and Attorney General Marshall, you and several other attorneys general, including Alan Wilson from South Carolina, penned a letter to 53 asset managers. In this letter, you said that state and federal laws require these asset managers to act as a fiduciary in the best interests of their clients and exercising due care and loyalty. So today I want to take a quick look at the history of fiduciary. Starting with the basics, the Bible says that no one can serve two masters. The Romans defined a fiduciary as a person holding the character of a trustee or character analogous of a trustee in respect to the trust and confidence involved in it and the scrupulous good faith and candor which it requires. The case of Keach versus Sanford, a 1727 English trust law, holds that a trustee owes a strict duty of loyalty and care so that there can never be any possibility of a conflict of interest under ERISA. A person who provides investment advice has that same fiduciary obligation to provide the advice in the sole interest of the plan participants. It's clear that the history of fiduciary is not a new concept. So why are these asset managers now struggling with that duty? When someone invests their money, they have the intention that this money will grow and that they will get a return on that investment. However, these asset managers are throwing money in support of ESG initiatives that are contrary to those who have those holdings. Attorney General Reyes and Attorney General Marshall, will asset managers be forced to choose between their legal duties to achieve financial returns and ESG policy goals, and can you outline that?
I think clearly there is a conflict, and one of the things that I would identify previously is the role of pension funds in states, and we've had two of our attorneys general, both in the states of Kentucky and Louisiana, in examining the question of fiduciary duty, have concluded the consideration of ESG factors would in fact violate state law. The laws in Kentucky and Louisiana are very similar to the laws throughout our country, very similar to the way that this body has defined fiduciary under ERISA, and has identified that as the sole interest duty of loyalty. Very specifically, the Michigan Supreme Court many years ago said that a business corporation is organized and carried out primarily for the profit of stockholders. The role of asset managers is to maximize the return on that investment. Again, particularly for the hardworking Americans who have invested their retirement dollars, their concerns principally is what's going to be there when I'm done. It's not necessarily on some of the factors that are subjective within ESG, but instead to those objective factors that qualify to determine what investment should be recognized. Interestingly, my colleague from Illinois referenced glasses and an optometrist that had given him the glass prescription. An optometrist uses devices to objectively determine what your vision is, to be able to make sure that you have the right glasses, that you're not using the wrong ones. ESG criteria very differently are not objective, they're subjective. And one of the reasons why we know that is the rating agencies themselves can't agree on what the factors should be, and they also score individuals quite differently depending on their subjective view of those companies. One thing that's also clear is that certain subjective ESG factors are in conflict. For example, let's take solar powers. That if you have a company you want to be able to score well because they have converted to solar energy, we also have to recognize that that solar energy is coming from materials and manufactured in China where forced labor practices are not acceptable. Which one do you favor more?
Attorney General and Attorney General Reyes, I want you to answer this one if you can for me, because I'm crunched for time, but are asset managers required to tell their clients when they enter in these ESG-related pledges? I mean, doesn't that seem to be kind of a problem? Because my understanding is that they do not have to disclose that.
I'm sorry, could you repeat? I know your time's up, but I didn't.
Are asset managers required to tell their clients when they enter into these ESG-related pledges?
Not currently, and that would be something that the Trump rules that the Department of Labor rule just changed previously required. If it was a tie and it's an intricate answer, but yes, there had to be transparency and disclosure and an explanation. Those rules have now gone away because of the current administration's hostility, again, towards that. So it would be advisable, but there's not a requirement per se. You could read into their fiduciary duty, and I think implicitly there ought to be, but right now, there's no statutory duty.
Thank you both. Thank you, Mr. Chairman. With that, I yield back.
Gentleman yields back. Chair recognizes Ms. Porter from California for 5 minutes.